Before we start with the proceedings, there is an order that I need to grant. I've briefly set out reasons for the order so that everyone should understand why I'm granting the order. On Friday, 7 March 2014, there was a request for a variation of my court order granted last week in respect of witnesses who had objected to being filmed and having their photographs or images published in the media. The objections had been brought in terms of paragraph 5.11 of Judge President Mlambo's order handed down on 25 February 2014. Immediately after I had granted the order, it became clear that there was some concern from the print media that my order had gone further than the order of Judge Mlambo in restricting the media. In brackets, see paragraph 5.10 in this regard, close bracket. Hence, the meeting in my chambers with counsel of all parties involved. Counsel for the print media submitted that the order of this court prohibiting the taking of still photographs of objecting witnesses, not only while the witnesses are giving evidence, but for the duration of the trial, is unheard of. He based this submission on the fact that normally photographs of witnesses are taken and published without any restrictions once the witnesses have been excused by the court. That may be so. However, we are here not dealing with a normal situation. We are dealing with a case that has attracted huge public and media interest. In my view, it is precisely because of this very reason that a cautious approach has to be adopted. Of course, the main question always is, what is in the public interest? The objecting witnesses have inter alia pointed out that their televised evidence may well cause them to be recognized by multitudes of people as, I quote, having given evidence in the Pistorius trial, close quote, and then having to deal with the public perceptions of that whilst attempting to lead normal lives. In my view, this applies to still photographs as well. There is no reason why the print media should be treated differently as being recognized on film or from a still photograph have the same effect. Before the trial began, the possibility of the objecting witnesses having to deal with the public perceptions as set out above may have seemed remote. However, since the trial began, it was brought to my attention that 2 of the witnesses had their integrity attacked in the social media after they had given evidence and after they had been photographed while leaving this court. These are witnesses who inter alia specifically stated in their written objections that they hold dear the inviolability of their private family lives. In the same way that this court has a duty to protect press freedom and freedom of expression, it also has a duty to respect the dignity and privacy of witnesses who have taken the trouble to come and give their evidence. This court also has a duty to protect those witnesses where it is possible to do so. If the protection offered by prohibiting filming or publishing of photographs while the witness is giving evidence is not adequate, then that protection must be reviewed and extended to cover a situation which was obviously not envisaged before this trial began. Junior counsel for the state stated that the duty of the state towards its witnesses does not end the minute the witnesses step out of the witness box. That duty continues until the trial is over. she distinguished between what she referred to as private witnesses and public figures. Excuse me. She suggested that the prohibition to filming and publishing of photographs of objecting private witnesses should be in place until the end of the trial. I agree with that suggestion, as I am of the view that private witnesses are more vulnerable than public figures. I'm also of the view that it would be in the interest of justice to make this distinction clear in the order. Before I grant the order, I wish to thank all counsel in this matter, including counsel representing the media, for their cooperation and assistance. The order that I shall grant will clarify the order that I gave last week and also vary it slightly. In the result, this court's order of 4 March 2014 is varied to the following extent. 1. In respect of an objecting witness who is a public figure, 1.1, the print media is prohibited from publishing any photographs of such a witness, irrespective of the source of the photograph, for the duration of that witness's evidence. 1.2, once an objecting witness who is a public figure has finished giving evidence and has been excused by this court, the ordinary rules applicable to the publication of photographs of witnesses in criminal trials apply, namely that photographs of witnesses that have been lawfully obtained may be published in the print media. 1.3, the order in 1.2 above does not permit the publication of photographs of objecting witnesses which are taken while they are giving evidence. Paragraph 2, in respect of an objecting witness who is not a public figure, in brackets, a private witness, close bracket. 2.1, the print media is prohibited from publishing any photograph of such a witness, irrespective of the source of the photograph, for the duration of the trial. Paragraph 3, this order incorporates an undertaking by the print media which reads thus. 3.1, that the 2 pool cameras will remain stationary in court at all times, including during breaks when the court is not in session. 3.2, the pool cameras will at all times during court sessions and outside of court sessions respect the personal space of any person in court. 3.3, the print media will delegate a candidate attorney from Willem de Klerk attorneys to be present in court every day to ensure that the pool cameras stick to the rules and to act as a point of contact person for complaints from either the state or the defense teams.
As a court, please. Court pleases, my lady.
Thank you. The witness is still under oath?
Hier is nog steeds onder eed om die waarheid te praten, nee. Yes, my lady.
Thank you very much. Yes, Mr. Lee.
Thank you, my lady. Mr. Baba, good morning.
Ik zei moeder. Morning, say.
On Friday, I dealt with the telephone calls made to security from Mr. Pistorius and from residents.
Ja, hij zei vrijdag het ons oor die oproepen gepraat. Wat van meneer Pistorius gemaakt was, zowel als die inwoners.
Dat is recht, my lady.
That is correct, my lady.
And in respect of the landline, I want to show you a document that we received from the police.
Hy sê ten opsigte van die landlyn wil meneer hoe u dokument wat hulle van die polisie af ontvang het wys.
Sorry, my lady, I just need to get the correct document. Lady, I will make a copy available to the court and the learned assessors as well. I think the last exhibit was P, my lady. P1 and P2.
Yes, that's right.
This document consists of 4 pages. Maybe it would be appropriate to mark it with your leave as Q1 to 4. This is one for you, and I'll make available to the court. If you go to the first page, Q1, right at the bottom, I'm not going to read in numbers, Mr. Baba. What I can tell you, it's a document that we received from the state, and that it's calls received by the security at this estate on its landline.
Hy sê as jy na die eerste bladsy kyk nie, hieronder. En hy sal geen verwysings maak nie. Dis 'n dokument wat hy van die staat af ontvang het, en dis ten opsigte van die oproepe wat die sekuriteitsbeamptes ontvang was.
It will show incoming calls to the security landline.
Ja, dis die oproepe wat ingekom het na sekuriteit van 'n landlynnommer.
The first one that's of importance is at the bottom of page 1.
Wat van belang is hieronder op die eerste bladsy.
We have Dr. Stipp's number. You can accept. It is his number.
Ons het Dr. Stipp se nommer.
And he made a call to you to security, the landline 31551.
Ja, ek kan miskien net 'n oproep na sekuriteits om 031551 gemaak.
Now that was to help you, Mr. Baba. If you see the next page, you see 2 calls at 31613 and 31636. That's on Q2, the 2 top entries.
Ja,
that is
om u te help kan jy na die tweede bladsy kyk, nee. Die 2 oproepe. Die van 031636. U sien dit mos nie.
Those are the 2 calls.
Dis die 2 oproepe
Just to help you, those are the 2 calls from Mr. Nhlengwetwa.
van meneer Nhlengwetwa.
So what you see is, and I think in accordance with your evidence, the first call you received was from Dr. Stipp.
Volgens die getuienis het hy gesê die eerste oproep wat hy ontvang het was van Dr. Stipp af.
Where he told you that he had heard gunshots.
Toe hy in kennis stel dat hy skote gehoor het.
Dis reg, Edel.
That is correct, my lady.
And we know now the time of that call, it's 3:15 and 51.
En ons weet dat die tyd was al 03:15:51.
Dis reg, my lady.
That is correct, my lady.
And we know that call, the duration of that call was 16 seconds.
En ons weet dat die durasie van die oproep 16 sekondes was.
Dis reg, my lady.
That is correct, my lady.
That is the call where he told you that he had heard shots. Is that correct?
Ja, dis die oproep toe hy gesê dat hy skote gehoor het. Was dit so?
Ja.
Yes.
Now, in the evidence of Dr. Stipp, he denied that he got through to you in that first call and said that it was much later. We know long after 3, or sometime after 3:17.
Ja, dokter Stip het gesê op die eerste maal het kon nie die deur kom nie. Eers later.
But we see that the call before Mr. Ndletwa, that it was in fact 16 seconds. Are you positive that he did speak to you?
Maar ons sien is volgens meneer Ntengeta se oproep was het 16 secondes. Dus is zeker dat hij wel met die het hele gebeld.
Dr. Stip's call.
Dokter Stip.
My lady, ek het met Dr. Stip gepraat.
Ja.
My lady, I spoke to Dr. Stip.
En ek het met meneer Ntengeta gepraat.
And I also spoke to Mr. Ntengeta.
Now, then we know, if we go to the security cell phone number,
Dit weten ze als ons naar die securiteitscelnummer toe gaan.
that I will make available to you that we received this morning. We had the document,
Dat zal je aan u uw aandag. Hulle het
but we
geopend ontvangen.
received
Lê
this
die
morning
document.
from the state of call data
Hulle het de oproepdata van die stad ontvang.
to and from the cell phone number of your security.
Zowel als van die celnummer van jullie securiteits.
I'm going to hand the document to you, my lady. Would you accept this as exhibit R1? Just R. Exhibit R. If you go to the...
You have it received.
I apologize, my lady. My apologies, my lady. I thought that it was saying it to you. We go to item 14 from the top.
Ga naar item 14 van hoe af. Tel tot 14.
And just keep your finger there.
En nou je vinger af.
I don't believe it's in dispute from the state side because we also have the call data from Mr. Pistorius' phone to
Ja.
show the outgoing call. That is the call made by Mr. Pistorius to security.
Die staat ontkent het ook niet. Al is hem aan dat er wel een oproep gemaakt was van de Pistorius zelf. En dat is die tijd waar hij gestipuleerd is. Zie je dat?
And that call was made on 14 February 2013 at 3:21
En daar
and
oproep was op
33
die
seconds.
14e van februari gemaakt. En die tijd wat meneer Roes zegt.
It
Ik zie
is
het moest daar niet.
3:21 and 33 seconds.
Ik zie niet dat.
Ja.
23 en 13 seconden.
You will see it was 9 seconds. And Mr. Pistorius will tell the court that he could not speak. He was
Ja.
indeed only crying.
Meneer Pistorius zei op dat stadium kon hij niet praten. Nie. Ik maar net hij.
Dis reg hier.
And
Dit
then,
is correct, my lady.
very shortly after that, although your statement says 3:24, you return the call, that's item 15 from the top.
15 van
You
de
return the call at 3:22:05.
Zie niet dat. Zie niet dat je dat. Meneer het zien.
Ja, ek sien dit.
Yes, I see the time, my lady.
And obviously, what I ask you about is that you saw it was a call from Mr. Pistorius. He was crying, and that caused you to call him.
En hij zei, soos wat hij dat aan u gesteld het. Die het gezien dat het een oproep van meneer Pistorius was. En dat is de reden waarom hij om iedere gebeld het, nee.
My lady, ek het vir meneer Pistorius gebel eerste.
My lady, I found Mr. Pistorius feest.
En meneer Pistorius het my teruggebel daarna.
Mr. Pistorius then called me back
is waar
afterwards.
meneer Pistorius het gehuil het.
And that is true. It is true, my lady, that Mr. Pistorius had been crying.
I understand that's your evidence. What I'm saying to you, we prove to you now, and we have the outgoing call data of Mr. Pistorius' phone call. He phoned you at 3:21:33, and you returned the call 3:22:05, about 50 seconds later.
Ja,
40 seconds.
meneer, hoe stel het dan hier dat meneer Pistorius jullie om 3:33 gebeld het, toen jullie om teruggebeld, ten 3:22.
Volgens, my lady, volgens wat advocaat Roel aandring is dat dit beteken meneer Pistorius het my eerste gebel. Van volgens die tyd wys dit 3:21 het meneer Pistorius my gebel. En tyd op die oomblik het ek nie gekyk, maar op die tyd wys dit dat meneer Pistorius het ek vir meneer Pistorius eerste gebel. En
My
nie-
lady, the manner in which Mr. Roel puts it to me, it seems as if like he's stressing the point that Mr. Pistorius was the person who called me first. That is not true. I'm the one who first called him. And according to this data, it shows that the time stipulated on the data states 3:21. And I'm the one who called him first, my lady.
Yes. Well, Mr. Baba, I understand that was your evidence. What I say to you, and we'll make that available to the court as well, we have a double record, a confirming record, and that's the outgoing call by Mr. Pistorius confirming the 3:21:33. So his call was first and yours was second.
Ik stel, dus wat ik het aan u stel, want daar is een ander document wat bewijst dat meneer Pistorius jullie wel om 2:33 gebeld. Hij heeft eerst gebeld en jouw oproep was die tweede. Dat zal u op die document zelf zien.
My lady, dit is duidelijk dat ons tye is niet diezelfde nie.
My lady, it's obvious that our times are not the same.
I also show you a chart done by the state, handed to us. Which we'll hand up as Exhibit S for only one point. And that is that you will see, we know, and that should not be in dispute. I don't want to read out a number, but if you go on the left-hand side of that chart,
Ga naar die linkerkant van die chart.
you will see various numbers. The fourth one from the top, it says Adrian Pretorius. We know that was the security cell phone number.
U sien mos hier aan die linkerkant nie, die boer wys het. Adrian Pistorius en sowel as die selnommer.
And then we go to the relevant cell number right at the bottom of Mr. Pistorius.
Dan gaan ons na die onderste gedeelte en dis ook meneer Pistorius se nommer. Sien jy dit? Praat man.
Ja.
Yeah.
Yes.
Ja, my lady.
Yes, my lady.
My lady, before I fail to bring this to your attention, I know that certain of the exhibits are available to the public or to the media. I ask my lady to consider to exclude this one for the simple reason that it, and the previous document, that it has various cell phone numbers of witnesses and Mr. Pistorius. And we've seen a history in this matter, and I believe this is, and the previous document, and all documents containing cell numbers should not be made available.
Yes, Mr.
I
Mayor.
support that request a lot.
Yes. Thank you very much. Exhibit S is not made available to the public.
Thank you, my lady. May I also ask the same in regard to Exhibit R?
Exhibit R is also not made available to the public.
My lady, my apologies. The same would apply to Exhibit Q. Q1
Q
to
as
Q4,
well.
also telephone number.
Exhibit Q1 Q2, Q3 and Q4 are not made available to the public.
Thank you, my lady. Now, Mr. Baba, if you will see, if you take your finger to the fourth entry from the top on the left-hand side, you will see a telephone number there. That just accept that is the security cell phone number.
Op die vierde link sal ons aanvaar dat die sekuriteitsnommers, nee. Sien jy dit?
Dis reg, my lady.
And on
Dit is
top
correct,
of the
my lady.
page, you will see the time periods.
En hierbo, kan jy mos dit hier sien, nee. Sien jy dit?
And this was the analysis done by the police in the state,
En dis die analysering wat hierdie polisie sowel as die staat gedoen was.
dealing with incoming calls and outgoing calls.
Ten opsigte van oproepe wat ingekom het en oproepe wat uitgemaak is.
And if you go to the fourth entry from the top, you will see a call coming in from Mr. Pistorius, and then thereafter, you returning the call back to that number.
Jy sien is hier op die vyfde kolom, dis meneer Pistorius se oproep wat hy na julle toe gemaak het. En na dit is dit julle wat hom teruggebel het. Jy sien dit mos net.
Dis die een.
Ja.
My lady, ek vra net dat meneer Roux net weer die vraag herhaal.
So what
My lady, I just request Mr. Roux to repeat the question again.
I say to you, I bring you a second document where it states that the analysis, where it is also shown that the first call to security was made, to the security cell phone number was made by Mr. Pistorius, and then the call was returned back to Mr. Pistorius.
Jy sien is die eerste
By
oproep wat was deur meneer Oscar Pistorius na julle toe gemaak. Toe bel hulle hom terug. Sien jy dit?
Eerlik is nie, my lady, ek is nie seker met meneer Pistorius se foonnommer.
My lady, I'm not sure about Mr. Pistorius' numbers.
You can accept, Mr. Barber, that Mr. Nell is sitting there. It is in fact his cell phone number, that's not in dispute.
You can
just don't
aanvaar.
want to read it out.
Daar is die aanklaer. Die staatadvokaat.
En
Hy
die
weet
ander
ook dat
number.
dit sy nommer is.
And the other number is indeed the security cell phone number.
Jy moet dit aanvaar. Sowel as die sekuriteitsnommer.
We just don't want to read it out.
Ek
Both.
wil dit net nie lees nie. Hier is dit uit. I just don't understand your question.
Ek verstaan nie meneer Roux.
I don't understand your question, Mr. Roux.
Yes. Well, what I say to you that I've put proof before you that in fact Mr. Pistorius phoned first and you returned that call very shortly
Meneer
after his
Roux
call.
sê hy gaan dit bewys dat meneer Pistorius eers gebel het en kort daarna het hy hom teruggebel.
Toe ek op meneer Pistorius voor meneer Pistorius se huis arriveer, het ek die call eerste van meneer Pistorius gemaak. Dis hoe ek uitgevind het dat daar iets fout is by meneer Pistorius huis.
Upon my arrival at Mr. Pistorius' house, I'm the first person who called him, and that's how I learned to know that something was wrong.
And I say that call was made before your arrival, before you arrived at
Hy
his
sê die oproep was gemaak voor julle daar aangekom het.
My lady, as meneer Pistorius het my eerste gebel, dan het ek geweet daar is iets fout by meneer Pistorius huis.
If Mr. Pistorius was the one who called me first, then I would have known that something was wrong at his house.
And what I put to you, it would make sense, Mr. Barber, that if Mr. Pistorius phoned you and he was crying on the other side, that you would phone him back to find out if he was okay. That would just make sense.
Wat sin kan maak is dat, stel nou maar as Mr. Pistorius jou gebel het, en jy kon hoor dat hy gehuil het, en as jy hom teruggebel het, dit maak baie goeie sin.
Well, it's more than that, that you would have phoned him back to ask him if he was okay.
Ja, as jy so hom teruggebel het, net om uit te vind, of hy okay is.
My lady, ek het vir meneer Pistorius gebel.
My lady, I called Mr. Pistorius,
En meneer Pistorius het vir my gesê, everything is fine.
and Mr. Pistorius told me that everything is fine.
Maar ek het agtergekom meneer Pistorius huil.
That's when, but I realized that Mr. Pistorius is crying.
En voor ik nog kan gepraat heb verder, het die phone afgegaan tussen ons.
And before I could speak further, that's when the line went dead.
Een paar seconden daarna heeft meneer Pistorius mij gebeld.
And a few seconds afterwards, Mr. Pistorius called me.
Hij heeft niet gepraat, hij heeft net gehuild.
He didn't speak, my lady was just crying.
En die phone het weer afgegaan.
And the line went off again.
Mr. Baba, if the sentence is a bit long, please ask me to break it up. I'm going to try.
Is die as die sin te lang is, vra maar net laat hy dit
It would be twofold. The one is that it would make good sense if Mr. Pistorius was crying on the phone, that you would phone him to ask him if he was okay.
Dit maak sin, sy nou maar uit gehuil oor die phone. Jy sou hom teruggebel, het net om uit te vind of hy alright is.
Dis reg, as my cliënt hier.
That is correct, my lady. He is my client.
Yes. I want to take you to the state's further particulars, which version the state elected to rely upon. My lady, it is in relation to the further particulars at paragraphs 9.1 to 9.3.
Hy sê sy sal terugneem na die staatse weergawe wat die staat maak.
Dis reg, my lady.
And I'm going to read to you the exact sentence.
Jy moet nou luister na die sin wat hy gaan uitlees.
The security called him, that's now, I put in brackets, Mr. Pistorius.
Die staat beweer dat die sekuriteitsbeampte vir meneer Pistorius gebel het.
And when asked by the security guard, after he had shot the deceased, if everything was in order,
En toe die sekuriteitsbeampte hom gevra het na hy die oorledene geskiet het of alles in orde was.
and then the important part,
En dan die belangrikste deel,
he indicated that he was fine.
hy het gesê hy's fyn. Sal dit in Engels stel.
Not that is the version chosen by the state.
Dis die staatse weergawe wat die staat gekies het.
Not that security, everything is fine. It is with reference to Mr. Pistorius. He indicated that he was fine.
Nie dat everything is fine. Verwysing na meneer Pistorius, hy het aangedui dat hy alright was.
My lady. Dit wat ek vir jou nou gesê het, dit is die waarheid.
My lady, what I just told the court is the truth.
As ek die oggend meneer Pistorius se woord gevat het, everything is fine.
If I accepted Mr. Pistorius' word that morning when he said everything is fine
En sy perseel verlaat het,
and left his premises,
wat sou dan gebeur het, my lady?
what could have happened then, my lady?
En hoekom meneer Pistorius nie persoonlik eerste vir ons gebel het nie?
And why didn't Mr. Pistorius call us personally initially?
En meneer Pistorius het ook alarmstelsel as hy verwys het daar was intruder.
And Mr. Pistorius does have an alarm system if he alleges that there was an intruder.
Now, can you remember, Mr. Baba, that same day at 1 o'clock you made a statement to a policeman called Hilton Botha?
Onthou jy dat u op die betrokke dag ongeveer 1 uur aan verklaring by meneer Hilton Botha afgelê het?
My lady, ek was met die polisie 1 uur die middag.
My lady, I was with the police around 1 o'clock in the afternoon.
And can you remember that I took a statement from you?
Onthou jy dat hulle 'n verklaring van u geneem het?
Dit was so besig edele en ek was uitkom met 'n nagskof uit.
My lady, it was so busy and I've just knocked off from night shift.
En ek het verklaringe afgegee vir hulle.
And I did make statements to them.
Can you look at this statement that I showed to you of the 14th and then confirm to me whether that was in fact the statement that you made to...
Meneer, kyk na die verklaring en sê of wat is die verklaring wat hy aan die polisie gemaak het?
Lady made that be made available as Exhibit T. May I similarly ask my lady in the top of the page, only in respect of the top, there's a reference to cell phone numbers and that may not be published.
Yes. The top of the page should not be made available to the public.
Thank you, my lady.
That's the first sentence.
It's the first paragraph, in fact, my lady.
Duration of the trial is unheard of. He based this submission on the fact that normally photographs of witnesses are taken and published without any restrictions once the witnesses have been excused by the court. That may be so. However, we are here not dealing with a normal situation. We are dealing with a case that has attracted huge public and media interest. In my view, it is precisely because of this very reason that a cautious approach has to be adopted. Of course, the main question always is, what is in the public interest? The objecting witnesses have inter alia pointed out that their televised evidence may well cause them to be recognized by multitudes of people as, I quote, having given evidence in the Pistorius trial, close quote, and then private family lives. In the same way that this court has a duty to protect press freedom and freedom of expression, it also has a duty to respect the dignity and privacy of witnesses who have taken the trouble to come and give their evidence. This court also has a duty to protect those witnesses where it is possible to do so. If the protection offered by prohibiting filming or publishing of photographs while the witness is giving evidence is not adequate, then that protection must be reviewed and extended to cover a situation which was obviously not envisaged before this trial began. Junior counsel for the state stated that the duty of the state towards its witnesses does not end the minute the witnesses step out of the witness box and having their photographs or images published in the media. The objections had been brought in terms of paragraph 5.11 of Judge President Mlambo's order handed down on 25 February 2014. Immediately after I had granted the order, it became clear that there was some concern from the print media that my order had gone further than the order of Judge Mlambo in restricting the media. In bracket C, paragraph 5.10, in this regard, close bracket. Hence, the meeting in my chambers with counsel of all parties involved. Counsel for the print media submitted that the order of this court prohibiting the taking of still photographs of objecting witnesses, not only while the witnesses are giving evidence, but for the Before we start with the proceedings, there is an order that I need to grant. I've briefly set out reasons for the order so that everyone should understand why I'm granting the order. On Friday, 7 March 2014, there was a request for a variation of my court order granted last week in respect of witnesses who had objected to being filmed, having to deal with the public perceptions of that whilst attempting to lead normal lives. In my view, this applies to still photographs as well. There is no reason why the print media should be treated differently as being recognized on film or from a still photograph have the same effect. Before the trial began, the possibility of the objecting witnesses having to deal with the public perceptions as set out above may have seemed remote. However, since the trial began, it was brought to my attention that 2 of the witnesses had their integrity attacked in the social media after they had given evidence and after they had been photographed while leaving this court. These are witnesses who, inter alia, specifically stated in their written objections that they hold dear the inviolability of their